Okay, I'm already going to kick this off. Thank you, everybody, for joining us. My name's Laura Dubinsky, and I'm a member of the public law team at Doughty Street, and I have the privilege of chairing today's event. In July 2021, the Supreme Court handed down a trilogy of judgments which are apparently indicative of a more restrictive approach to policy challenges and also to the deployment before the domestic courts of the UK's unincorporated treaty obligations. Two brilliant, quite new members of our public law team are here to address you on those judgments. Alice Irving is going to address the judgments in A and BF Eritrea concerning policy challenges. And Alice's principal practice areas are housing law, community care, and education, with a particular focus on the rights of the disabled. She was formerly an academic before coming to the bar, and was a finalist at the 2021 Legal Aid Lawyer of the Year Awards for Legal Aid Newcomer of the Year. After Alice, Mike is going to address you on the case of SC. SC is a discrimination case, but takes in a broad range of other issues, including the deployment of unincorporated treaty obligations and the use of parliamentary materials. Mike practices in civil and public law, and his particular expertise is in immigration and social welfare cases. Before coming to the bar, he was the legal officer for the Child Poverty Action Group, and he was also judicial assistant for the much missed Lord Kerr. A few housekeeping matters before we kick off completely. There will be about 15 to 20 minutes at the end of this seminar for questions. So please, as questions occur to you, send them through using the Q&A function. Because there's so many participants, I think around 145 or 147 have signed up, you won't all be visible or audible, but we will be able to see your questions. If there are any technical problems that you want to raise, you can send those through the same Q&A function, but you've also hopefully received just now the email address of our Chambers facilitator, Ramunda, who's very kindly at hand to help. And now I'll turn over to Alice.
Thanks very much, Laura. So as Laura said, I'm going to be speaking about the two cases, RA and BF Eritrea, which talk about challenges to policy. First of all, though, before I get onto that, because both of those cases, and particularly RA, speak quite a lot about historical or previous cases in this area and seek to clarify what they mean, I think it's useful to do a very quick whirlwind tour of the cases that are most significant that are referred to in those judgments. So if I could have the next slide, please. So the first of those is Gillick, which has obviously been in the news again recently, although for a different reason. And it's best known, obviously, for the competency and capacity test which it lays down for young people. But obviously that was a challenge to the guidance issued by the Department of Health in that case about the ability of doctors or how the approach they should take to prescribing contraceptive services to under 16-year-olds. And so it was a challenge to guidance for policy. And in that judgment, this is the key paragraph from Lord Scarman, setting out that guidance will be found to be unlawful if it permits or encourages unlawful conduct. Now, the bulk of that case was also obviously talking about, well, what was lawful and unlawful. But at the end of the day, this was the test they applied when determining whether or not that guidance was unlawful. And obviously they found that it didn't permit or encourage unlawful conduct because they found that an under 16-year-old in the right circumstances could consent to contraceptive services. So that was way back in 1985, and that was the House of Lords. If I can come to the next slide, please. So the next really significant case, which is discussed by the Supreme Court in RA, is the Refugee Law Centre case. Now, this was in 2005 before the Court of Appeal, and the underlying factual matrix was that this was a challenge to a fast-track scheme for the processing of certain asylum applications. And essentially what that scheme did was, for applications which were screened as being sufficiently simple and involving certain types of asylum seekers, it condensed the decision-making process for an asylum application to just 3 days. And the challenge was brought on the basis that there was real concern about whether asylum seekers in these cases would have a fair opportunity to put their case. It was common ground that in the simplest of cases, 3 days would be sufficient for the process to be procedurally fair, but the concern was about those cases which were more complex and whether there was sort of sufficient flexibility in the system to enable more complex cases to be dealt with on an extended timetable to ensure that was fair. And here we have the key paragraphs from the Refugee Law Centre judgment as to the approach taken to determining whether that policy was or was not lawful. And we get this language of inherent unfairness coming through. So does the policy create an unacceptable risk that there will be unfair processing of the application? And that should go beyond just the risk that's inherent in any system, or I shouldn't say inherent, the risk in any circumstances that there will be aberrant decisions by individual decision makers. Has to be some kind of risk that inheres in the system itself. So out of Refugee Law Centre, we get this idea of inherent unfairness built into a policy, and that is sort of explained as being an unacceptable risk of being processed or dealt with unfairly under that policy. So if we can come on to the next slide, please. So the Refugee Law Centre kind of framing of that issue was really picked up and run with by the Court of Appeal in the case of Tabuk, and that was in 2014. And so this case, the underlying factual scenario, and I know I'm going at pace here, but I want to get to the actual recent judgments. I'm sure that many of you are familiar with these prior judgments. The underlying facts in Tabuk were that this was about the imposition of additional license conditions on people who were being released from prison in relation to certain types of offending. And in this instance, the claimant was had been convicted of terrorist offending. So the question was whether the policy documents in place, which governed the process by which it was decided what additional license conditions can be imposed on somebody, whether that process allowed an adequate opportunity for the individual in question to feed in their views and to make representations about those various conditions that would be imposed upon them. In this case, the individual was subject to electronic tagging, and his position was that that was deeply detrimental to his mental health, and the issue is whether there had been a fair opportunity under the policy framework for those views to be taken into account. So what we see coming through in Tabuk is they build on the Refugee Law Centre test. They frame that again in this language of inherent unfairness, and they say that that basically means there's an unacceptable risk of the process happening in a way that's unfair, and that risk of unfairness is part of the system itself. Again, there's a distinction being drawn between whether we've got a risk that inheres in the system itself rather than the kind of risk of bad decision making, which is ordinary whenever you give a decision maker some power to make a decision. So if I can come to the next slide, please. Now, what's really important about Tabuk is the court goes perhaps one step further, arguably, than Refugee Legal Centre, and say that this approach is something to be considered that is distinct from the approach in Gillick. So you'll remember in Gillick, the question was whether the policy encouraged or permitted unlawful conduct on the part of the decision maker. The court in Tabuk expressly says that that's a very different or a separate question to the question being asked in Refugee Legal Centre, which is whether the system is inherently unfair, which is, again, this idea of equating it to an unacceptable risk of unfairness due to something inherent in the system. So what we have coming through in the Court of Appeal here is that there are two tests. One is Gillick, this idea of permitting or encouraging unlawfulness in the wording of the policy, and the second is this Refugee Legal Centre thread of reasoning, which is about an unacceptable risk of unfairness, which is inherent in the policy itself. So that's the backdrop in terms of the really key cases which the court talks about in the Supreme Court judgments that we're looking at today. Obviously, there have been a host of other cases applying and building on this content, but these are the really key cases which concern the Supreme Court when we come to RA. So if I can have the next slide, please. So RA, the first of a pair of judgments which are expressly connected. So you'll see that BF Eritrea is cross-referenced in RA and vice versa, although I would say the meat of the reasoning in relation to what I'm talking about is in the RA case, and I'll spend the most time on that. The judgments of the court are, for both cases, are written by Lord Sales and Lord Burnett, but they're explicitly for the entire court, so carry obviously quite a great deal of weight. In the RA context, we were talking about a challenge to the child sex offender disclosure scheme, and there was guidance that was promulgated in that context. Now, this is a scheme which enables an individual in the public to come to, say, the police and to ask whether someone who's working with children has some kind of history that might be disclosed in relation to child sex offending. The claimant in the case had already actually brought one successful challenge to the guidance in question, because previously the guidance didn't say anything at all about whether or not the individual offender in question, or ex-offender, should be approached and asked any questions about whether their views about whether a disclosure should be made when an approach by the public asking for information occurs. So there have been changes to the guidance which set out that they needed to sort of think about the Article 8 and common law rights of the individual ex-offender before making a decision about whether to disclose in any particular context. But the claimant was unsatisfied by the changes made to the guidance, and he came back for another go. And a sort of key part of this, and I think key to understanding the judgment of RA itself, is that effectively the argument was that there was insufficient specificity in the guidance in relation to disclosure. So it now did say things about obtaining representations from the ex-offender in question, but it didn't really provide a huge amount of detail in that regard. And the concern for the claimant was that the lack of specificity meant that it was possible that errors would be made in determining whether or not to obtain representations from the ex-offender prior to deciding whether to disclose the information. And I think that's really important context. And the reason for that is on the next slide, which is a really important aspect of the judgment is thinking about, well, what are the obligations on someone when they're promulgating policy? The first, the starting point is that often there's no obligation at all to promulgate a policy, although you'll all be aware, I'm sure, of the Lumba decision and the fact that in certain circumstances, Lumba or potentially the European Convention kind of context might require an authority to put in place a policy to enable there to be sufficient certainty in an area. Then there's this point that if a executive branch of the government or authority decides to promulgate a policy, it's generally up for them to decide how comprehensive that should be. And it doesn't need to be a textbook statement of the law. We don't want the courts, the Supreme Court's sort of say, going in there and kind of arguing that everything needs to be sort of set out and covered off and discretion needs to be narrowed as far as possible. It's really for that decision maker generally to decide how much detail to cover in a policy, and the courts aren't going to get involved, or at least this is what it seems to be saying, in saying that a policy fails to meet the standard by being insufficiently comprehensive. So that's the starting point. If I could have the next slide, please. So where does that leave what kind of challenges can be brought to policy? The court says at paragraph 46, and I'm jumping around the judgment in terms of paragraph order a bit because I think it helps to understand the flow of the case, that there are three circumstances basically where policy can be found to be unlawful by reason of what it says about the law. Now, I think that's really important. So this isn't saying that these are obviously the only grounds on which you can challenge a policy. It doesn't address, for example, fetter of discretion through a policy or any number of other grounds that are still available as a means of challenge. But when we're talking about a challenge based on what the policy says about the law, the Supreme Court says there are sort of three routes you can take. The first is that the policy contains a positive statement of law, which is wrong. And that was the kind of argument that was run in Gillick, where the sort of primary argument before the court was, well, under 16-year-olds shouldn't be able to consent to contraception. So because the policy says that they can in certain circumstances, that is wrong. And obviously they lost that on the underlying legal position, but that's the kind of shape of the argument that they're talking about there. And I'll expand that a bit more because it is obviously a bit more complicated than that. The second two really deal with the level of specificity point. The second is where an authority has a duty to promulgate a policy providing accurate advice. and they might fall into error either by misstating the law, so a positive statement which is wrong, or by omitting. So there are circumstances where not covering all of the ground or omitting something material which sort of skews the overall perspective of the law leads to a finding that the overall policy is unlawful. And then the third situation is where, although there's no absolute duty on the authority to promulgate a policy, either as a result of something laid out in statute, or potentially something like LUMBA, or again, the functioning of the Convention on Human Rights framework. But an authority nevertheless decides to promulgate a policy, and that policy purports to provide a full account of the legal position. So a fair, reasonable reading of the policy is that it's intended to be comprehensive, and then it fails to, in fact, be comprehensive. So again, that's a situation where you might be able to come in and say, well, this was meant to be comprehensive, it's not, and therefore a lack of specificity can be a basis on which you might challenge that policy. And usefully, the Supreme Court in this case indicates that one of the factors you might consider in determining whether or not a policy is sort of intended to be comprehensive is to look at the audience and the intended audience, and if it's, say, a department in a government sort of framework that would be expecting to take their guidance from, say, the Secretary of State, and wouldn't be expected to run off and seek other legal advice, that might weigh in favour of saying that the policy was intended to be comprehensive, although that's just one factor to take into account. So I think this is the background in which we start discussing challenges to policy. So the court is saying, just to recap on that, that generally speaking, a high level of specificity isn't required on a legal basis, but there are contexts in which specificity or an omission might be problematic. And I think those are particularly useful when it comes to sort of thinking about some of the potential limitations that this new case law places on policy challenges, to not forget that there is this initial door that opens here to be able to say that actually in certain circumstances policy ought to be relatively comprehensive, or at least not have sort of material omissions. And so keep that in mind when you're thinking about a policy challenge. Is this the kind of case where we can say either there was a duty to provide accurate, sort of relatively comprehensive advice, or does the policy as read purport to provide that? And then that gives you more leverage in a policy challenge. Okay, if we can move on. Thanks very much, Ray. So when it comes to this first of those three possible challenges, where they say, well, you know, leaving aside this idea of whether the policy was required to be comprehensive or not. So say we failed to show that it was a comprehensive policy such that an omission is something that we can argue is a problem. You can nevertheless still argue that the policy is unlawful because of the test in Gillick, which is it authorises or approves unlawful conduct. So this idea of permits or encourages. And you'll see in RA that when it says permit or encourage, there's a slight gloss on that wording where they say, you know, when we say permit, we don't just mean allow it to happen. We're talking about something that's sort of an act of authorization or approval of the unlawful conduct. So something in the guidance itself, which sort of, I guess, nudges the decision maker in the wrong direction is what you would be looking for. Can I come to the next slide, please? And the court unpacks a bit further what it means to apply the Gillick test. So they say that what you're looking at is you identify what the relevant law is, and then you look at the policy statement in terms of what it says a person should do, and you say, well, are they compatible or not? So the court is saying you're making a comparison of normative statements in law, an objective construction of what the policy document says, so how is it reasonably read, and what the court isn't, it says, interested in is someone coming along with statistical analysis about how the policy is in fact working in practice. Now, I'm going to come back to that because I'm not sure that this is the death knell for the use of statistics entirely, but there is the suggestion that what the court is looking at is the document on its face at the beginning before we sort of come down the line and say, well, is this actually working badly? And sort of producing statistical analysis showing that it might be working badly. That's not necessarily the kind of information the court is interested in. So if we can come to the next slide, please. I'm sorry for these large blocks of text. It's not normally my slide style, but I think because these judgments are a bit unclear and it's likely to be controversial what they mean, it's useful to take you to the actual text of what the Supreme Court said, so we can really think about the wording. So here I think is a really important passage of the judgment from paragraph 62 to 64, where effectively the court says there isn't a separate test coming out of Refugee Legal Centre into Buck, which is what was suggested into Buck, where they said, well, Gillick is one thing, unacceptable risk of unfairness is another. The Supreme Court was saying that they're effectively assimilated, they're both to be dealt with under Gillick. And as we'll see as we come to some later slides, the court's view seems to be that pretty much everything that would previously have been caught under the Refugee Legal Centre kind of line of cases should be caught under Gillick. So this isn't necessarily, I don't think, or at least arguably, it's not intended to be a narrowing of the scope of challenges that can be brought, but is instead a question of what's the question that the court is framing and how is that framed to start with. So I think a lot of people, when they first read these judgments, were really concerned that it marked a massive kind of turning point and that we were going to have a lot more trouble bringing policy challenges. I think actually when you read it again more closely, it's quite clear that what the court's saying is you've just got to frame the question in a certain way, but Gillick should cover the ground, at least it's arguable, should cover the ground to an extent that Refugee Legal Centre into Buck covered. So I think that's something that is quite useful, that you can resist any suggestion potentially by opponents that this is a narrowing of the policy challenge by saying, well, the court was saying that these were sort of assimilated and covered similar ground. And again, we get this idea here, it's no longer, you're not going to ask as a standalone question, is there an unacceptable risk an individual will be treated unfairly? But you are going to be asking under Gillick whether it can be seen at the outset, looking on the face of the policy, that a material and identical number of cases will be dealt with in an unlawful way. And I think that's really critical. That's in paragraph 63. And that, I think, shows how close the approach under Gillick, as articulated by RA, is to the approach as articulated under Refugee Legal Centre into Buck. I think what's maybe shifted is simply a point in time kind of question. So you're looking at the document, policy document, at the time it was promulgated, right at the beginning, and looking forward to say, can I see that there will be an identifiable and material number of cases that will be dealt with unlawfully, rather than, say, looking back after a period of time has passed and saying, we can show that there's been an identical number of cases that have been dealt with unlawfully. So I think that it is quite possible to argue that we've still got a good amount of scope under Gillick. It's just about framing any challenge now in the language of the test as set out by the court. If I can come to the next slide, please. The other really important thing about RA is that there's a clear distinction drawn between these challenges based on procedural unfairness and challenges based on anything that impacts on the right of access to justice, so the right of access to courts and tribunals. And the leading authority on that is obviously the Unison case, which concerns the employment tribunal fee changes. So in that case, the Supreme Court, and I think that was Lord Reid, stated that the test was whether there was a real risk that persons would be prevented from having access to justice. And the court in RA doesn't seek to overturn that. And they do also say that in the context of access to justice, it's legitimate for a court to have regard to evidence such as statistics regarding likely impact. And if you're familiar with Unison, you know that there was a deal of evidence about the impact of the changes to employment tribunal fees on the actual access to justice. So I think this is something else that's really important about RA. You have a judgment saying something about the use of statistics in the context of procedural unfairness, and it's saying when we decide if there's an inherent unfairness in a policy, we look at the policy document at the time, at the beginning, at the time it was promulgated, and we ask if we can see sort of from a normative, objective reading of that there will be a certain number of unacceptable number of unfair decisions going forwards. But in relation to access to justice, we are allowed to look at statistics about whether there has in fact been impact on access to justice. And I think that leaves open a really big question about, well, what's the effect of RA for other parts of the law and challenges in relation to policy? So for example, we all know that it's not lawful for a discretion to be fettered by a policy. What if we have evidence that in practice the policy is de facto fettering a discretion? Will it be the unison kind of approach where we're allowed to look at those statistics and say, well, this is evidence of the impact? Or will it go the procedural unfairness route where the court says we shouldn't look at evidence of that sort? And I think that the fact that there are these different approaches to procedural fairness on the one hand and access to justice on the other, which to my mind are very difficult to justify in terms of being different approaches, leaves open quite a lot of space in relation to other grounds of challenge to say that RA doesn't really touch those in terms of the use of statistics and evidence. If I can come to the next slide. And this is what I was prefiguring earlier. So I think this is a really useful paragraph where they basically say that the wider formulation of the test that we've seen previously, arguably the wider formulation under Refugee Legal Centre in Tabak, almost all of those cases are going to dissolve into either the Gillick or the unison principle. And so I think we can use this to suggest that this isn't meant to be an enormous narrowing in any sense of the kind of challenges that can be brought, but just a reframing of the question that needs to be asked in bringing those challenges. So I do think that's a useful paragraph for claimants. Very quickly then, BF Eritrea. And I know that I've spent a lot of time on RA, but as I say, I think the meat of the Supreme Court's thinking is in RA. So if I could have the next slide, please. So this again, same court, same two judges writing things up. If you're familiar with the case, this is about guidance on age assessment of asylum seekers. And again, the question was whether it created a risk, or at least the Court of Appeal found that the policy was unlawful because it created an unacceptable risk that more than a minimal number of children would be detained under the adult regime for asylum seekers, which would be unlawful. So we see this language of risk coming through in BF and Eritrea. And that was appealed to the Supreme Court. And if we can come to the next slide. So effectively what they say in Eritrea is what they say in RA, which is Gillick is the test. The test is not a standalone test of is there an unacceptable risk of error in, say, the assessment of a person as a child or an adult. And so to that extent, it doesn't really carry our analysis any further. I just think there's one paragraph that's interesting here. So what was different in BF Eritrea was that the legal team for the appellant in that case did try to fit their analysis under Gillick instead of relying heavily on the Refugee Legal Centre in Tabak line of cases. And the argument was that the policy fell foul of Gillick by permitting or encouraging unlawful conduct because it didn't sufficiently remove the risk of unlawfulness. So it didn't do enough to prevent children being wrongly classified as adults and therefore being detained unlawfully. And the court says at paragraph 51 that that's not quite the right reading of Gillick. So what Gillick is meant to be doing is you're meant to be comparing a normative statement of the law with a normative statement on a fair reading of the policy and deciding basically whether they match up. And they criticised the appellant in this case for saying that they were trying to compare a normative statement with a factual prediction about what would happen under that particular policy, and that's not quite right. Now, I would say that I think there's a good deal of porousness kind of at this boundary between normative statement and factual prediction, which is useful because obviously, if we're thinking about things like Refugee Legal Centre and a 3-day decision-making process, and you're talking about, well, are there a certain number of cases that will be dealt with unfairly because they're complex and they will be rammed into this 3-day timetable and that won't be good enough. You are making a factual prediction of sorts about whether or not there will be cases that are, are dealt with fairly and unfairly. At some point, it's clear that the court thinks that we're overstepping a boundary into sort of facts that a court can't deal with. But I'm not sure that I would say that this this paragraph means that you can't use evidence or say things about what factually might happen under a piece of policy in practice going forwards. And I think that's clear when you actually go through RA and look at how they've analysed some of the older cases, and they've said things like Refugee Legal Centre fits under Gillick if you just read it properly. So I think this is another place where there's wriggle room, because I think the difference between a normative reading of a policy and a factual prediction of what will happen under a policy is a fairly porous boundary. So I have utilised my time. We have a next slide, which is what next. I think during the talk, I've tried to draw out where I think there are points of ambiguity or wiggle room or questions, things that we might exploit as claimant lawyers in particular going forwards. But I think we'll come back to this a little bit more in questions at the end of the session to discuss the broader implications of RA and BEF for policy challenges. What I would say is that I think the first reading, a bit scary. Second reading, there's a lot more wiggle room to work with, I think, as claimant lawyers than perhaps was first apparent. So thank you.
Laura, you're on mute.
Oh. Ah.
You're still on mute, Laura. Okay, I will proceed. I will introduce myself. You've already heard the introduction from Laura, and thank you, Alice, for that very helpful talk. I'm going to look at the third in the trilogy of judgments issued by the Supreme Court in July of this year, and that's SC and others, which is the two-child rule case. Like the judgments that Alice has taken you through, at first blush, this one seems particularly concerning for claimant lawyers, and it appears that the Lord Reed Court is attempting to put a lid on public interest litigation. Definitely that's going on in this judgment, but also, like Alice, my thesis in relation to this judgment is that it's not as bad as it looks, and there is a considerable amount of wiggle room for claimants' lawyers. And while some of the dicta of Lord Reed can appear quite concerning, looked at in its context, the judgment is not actually saying anything particularly new about some of the matters in it. I'm going to focus, because it's a very rich judgment with a lot of relevance to claimant and public lawyers generally. I'm going to focus on two particular areas, and that's the court's review of the law, or the way in which the court dealt with the issues of indirect discrimination on grounds of sex, and secondly, the way in which the court dealt with the relevance of unincorporated international treaties in assessing compliance with Article 14 of the European Convention on Human Rights. If we can have the next slide, please. First, just to give you a bit of background about the judgment, this was a rule, or this is a rule of social security entitlement that limits entitlement to child tax credits and universal credit to the first two children in the household, where any third or subsequent child was born after the 6th of April 2017. It was introduced after the 2015 election in 2016 through primary legislation. Now, I was the legal officer at the Child Poverty Action Group during the coalition years, which was the height, really, of the welfare reform agenda. And so I lived through it and saw the impact of and brought challenges against the bedroom tax and the benefit cap, and we carried out those battles all the way up to the Supreme Court. But all of those policies, to me, this was possibly the worst, in that it really marks a departure away from an idea that every child is worthy of receiving subsistence support and a minimum standard of living, and focuses very much in a sort of Victorian moralistic way on the size of families within poor families, within poorer households, and takes a view that certain children in effect shouldn't be born unless their parents can afford to support them. And to me, that has a lot of concerns from a human rights perspective. So it was quite natural that my successors at CPAG would seek to bring a challenge against this legislation, very natural that there would be a consideration of its compatibility with human rights through the courts. But it is important to note when looking at this judgment that the claimant's challenge was always going to be ambitious. We're talking about a challenge to not only a piece of clear primary legislation, but one that was introduced following an express manifesto commitment on which the government had won a majority in the general election. It also in a field, social welfare, where there's recognised to be a very wide margin of appreciation. And the claimant's challenge was broadly put. They challenged on the two-child rule outright as a breach of Article 8 and the right to family life, also as a breach of Article 12, which was quite a novel argument, as a breach to the right to marry and find a family, and then various formulations in relation to its discriminatory impact under Article 14. I should say before we leave this slide that there are some limited exceptions that were introduced to the policy following debates in Parliament, but those have a very small impact, and that looks at multiple births, adoption and kinship carers, essentially because of the policy reasons why.
I'm on mute and I can't unmute myself.
Hello, Laura, I can hear you now. And a rather controversial exception related to non-consensual children conceived through non-consensual intercourse. Can we move on to the next slide, please? As I said, Lord Reid, who gave the judgment on behalf of the unanimous Supreme Court, covers a lot, and there's a lot in there that is very useful and interesting for public lawyers. In this slide, I've hoped to summarise the findings of Lord Reid, and you will see that he found that the two-child rule was compatible with Article 8 and with Article 12. There was a presumption of discrimination against women that did need to be justified, but there was no direct discrimination against children, no indirect discrimination against children, and there was direct discrimination that needed to be justified against children living in larger households. There were also a number of rulings on law in relation to justification, and the court clarified that it's not appropriate for the court to determine compliance with the UNCRC. It clarified the test for justification under Article 14, and that's essentially, in the context of social welfare, and that's essentially the manifestly without reasonable foundation test, a very difficult test to satisfy, but with recognition that that's a flexible test that may require strict scrutiny where there are suspect grounds, for example, sex or race. It clarified the approach to the use of parliamentary materials, which in summary is that they might be relevant when looking at justification, but only as background in accordance with the privileges of Parliament. And finally, made the crucial determination, which was that in the view of the Supreme Court, the two-child rule could be objectively, and its discriminatory effects could be objectively justified. Now, as I indicated at the outset, I'm going to focus, I can't hope to get through all of those issues in 10 minutes, but I'm going to focus on 2 and 6, so the court's approach to indirect discrimination against women and the court's approach to unincorporated international treaties. If we could have the next slide, please. Firstly, looking at indirect discrimination, and there has been a lot of commentary about this apparently concerning passage of Lord Reid's judgment, in which he says it's an objective fact that more women than men are affected by the rule limiting entitlement to 2 children in the household, because more women than men are bringing up children. And there's no suggestion that that in itself is discriminatory. And therefore, that differential impact on women is not a special feature of the measure. And taken in isolation, that might appear to suggest that the court has no concern whatsoever for structural disadvantage within society and for policies that fail to address structural disadvantage. And so policymakers policymakers don't need to concern themselves with the fact that women tend to be the ones who are more likely to be looking after children when formulating their policies. That's a misreading of this passage, and I think it's very important to go back through the judgment as a whole and see what Lord Reid was really saying here. And the starting point, and the important starting point really, is that the court did find that the two-child rule disproportionately impacts women, and therefore that there's a presumption of indirect discrimination that required justification. So Lord Reid reviewed the Strasbourg authorities under Article 14. He formulated the test from those Strasbourg authorities as being that where you have a neutrally formulated measure, that it disproportionately affects a particular group, in this case women, then there is a presumption of indirect discrimination on grounds of sex. That shifts the burden to the state, who must show that the measure in question is not discriminatory, and the state can only discharge that judgment by pointing to objective factors and showing that the measure pursues a legitimate aim and is proportionate. And all of that is entirely orthodox and in keeping with the judgments of the Strasbourg court and the domestic court when considering compatibility with Article 14 of the Convention. So, for example, in DH and the Czech Republic, that looked at the disproportionate number of Roma children who were in special schools, and that was justified by the Czech Republic on the basis that Roma had limited intellectual capacity according to their neutral testing. And the court found that that was a legitimate aim, but that it was disproportionate because the testing regime was inadequate. And similarly in SAS in France, which looked at the ban on face coverings in France, again, the burden shifted on the state to show that this measure, which had a disproportionate impact on the grounds of religion, was objectively justified. And in that case, the Strasbourg court found that it was. So having found a presumption or prima facie indirect discrimination within the two-child rule because of its disproportionate impact on women, Lord Reid then looked at whether it was could be objectively justified by the state. He identified two aims which he considered to, or the court considered to be legitimate as identified by Parliament, and that's reducing excessive expenditure within the welfare budget and a slightly more difficultly formulated objective, which is to do with fairness and the concern that by guaranteeing that each additional child in the household can be entitled to receive welfare benefits, this was unfair on those families that have to make more difficult choices, even though they may be better off. And Lord Reid held that those were two legitimate aims on the part of Parliament. He then looked at whether those aims were proportionate, and it's here that we see paragraph 197. And what Lord Reid said was, well, when you look at the aims as formulated by Parliament, the only way, however you formulated the policies, whatever exceptions you put in, they would always achieve a disproportionate impact on women. And he went on to say, indeed, any cut to welfare benefits would be likely, and this was the evidence accepted by the claimants, to have a disproportionate impact on women, purely by the fact that women are more likely to be claiming welfare benefits on behalf of children. And that's all he's saying here, but the analysis doesn't stop there. He then goes on to say, well, taking into account that fact, the fact that the aims, which is already established to be legitimate, could only be achieved by having a disproportionate impact on women, is the importance of the measure, is the impact on women outweighed by the importance of the objectives as formulated by Parliament? And his conclusion was, Parliament's made that judgment, and we find no basis to differ with that conclusion. Can we move to the next slide, please? I don't have time really to take you through a couple of other judgments, and perhaps we can discuss them in questions. I'm going to do that very briefly to say that there are two interesting judgments from the administrative court, which predate the ruling in SC, or the promulgation of the judgment in SC, which also appear to suggest to be putting a similar lid on indirect discrimination claims, looking at structural disadvantage within society. So we have Adiatu, which was looking at the rate of statutory sick pay and the disproportionate impact on BAME employees who might be unable to benefit from that. And if we can look at the next slide, the motherhood plan, which was a challenge to the self-employed scheme for coronavirus, the self-employed income support scheme, on the basis that the HMRC didn't take into account when assessing whether people were eligible for the scheme, didn't take into account that some women would have been on maternity leave and therefore would not have sufficient tax returns. And in both cases, the court said, well, look, the policies weren't concerned with that underlying disadvantage, and therefore they're not indirectly discriminatory. Now, the motherhood plan has gone to the Court of Appeal, and that hearing was, that case was heard in July, which around the same time as the judgment in SC. I'm not sure whether the judgment in SC was considered. It's not necessarily directly relevant because these were cases under the Equality Act. But I think those judgments are saying something different to what Lord Reid is saying in SC, and it will be very interesting to see whether the Court of Appeal corrects that, because it's quite concerning to say that a neutral policy on the lines of the self-employment scheme policy cannot be discriminatory even against pregnant women, because it doesn't take into account their periods of maternity. Okay, moving on to the next slide. I'll have to deal very briefly now with unincorporated treaties, but again, here we have a dicta from Lord Reid that appears to be very concerning, in that it suggests, read in isolation, that the UNCRC and other unincorporated treaties have no relevance to the human rights justification analysis. But again, that's not quite what the court was saying. What the court's saying is that he can't determine at the domestic level whether there has been a breach of the UN Convention on the Rights of the Child. But what it can do is take into account, and what the Strasbourg Court does, is take into account the relevance of international treaties when considering whether a particular measure is justified and when interpreting the convention. And part of this is because the claimants in this case, in the SC case, had put their case a little too highly. What they said is the court must determine whether there has been a breach of the UN Convention on the Rights of the Child because of a failure to take the children's best interest as a primary consideration. And Lord Reid says, no, absolutely, we can't do that. We can't make that determination. If I can look at the next slide. And if we can just turn to the final slide. But what he does say is that it is appropriate to take into account the best interests of the child as a relevant factor when assessing justification. And again, that's entirely orthodox and in line with the dicta from the Strasbourg Court. And so it is still relevant to consider the impact of policies on children when considering their compliance with the convention and their compliance with Article 14. I think that's all I have time for, but I think I've made my point in relation to the SC judgment, which is read it very carefully. And it's not necessarily as severe as it might appear at first blush, despite some of the concerning dicta. Thank you. Laurie, you're still on mute. Are you able to fix that?
Yeah. Am I now audible?
Yes, you're now audible.
Good. I'm very sorry about this. Maybe it's a good quality in a chair, though, to be on mute. But can I thank Alice and Mike for their clear and erudite expositions of difficult judgments and perhaps, in the case of A and BF, even internally contradictory judgments. I'm going to open up for questions. Question now for Mike that comes from Jeremy Ogilvy, and I really apologize if I'm mispronouncing, at the Harris Hackney Community Law Centre. Jeremy asks, is the Supreme Court in SC saying that claimants have to rely on official statistics to show discrimination? And Jeremy's particularly asking about paragraphs 50 to 51 of SC. And Jeremy says, if that is the case, then that seems a great obstacle to organisations such as the Child Poverty Action Group, and also a difficulty in situations where hardly any official statistics are available. Over to you, Mike.
Thank you, Jeremy. That's not my reading of paragraphs 50 and 51. I think the court is saying that it's permissible to rely on official statistics when looking at the disproportionate impact on women, or any particular group. But it may well be that a policy quite obviously has a disproportionate impact and doesn't require any statistics. I don't think the court is saying that it's that there must be statistics in every case, and I agree with you, that could be too high a hurdle. There are quite a lot of official statistics, so from the claimant's point of view, it is helpful to be able to point to them. Although this sort of links back to the judgments that Alice is looking at, in that as soon as you start to put statistics in, the court can sort of glaze over. And there is on some parts of some judgments, and certainly in some contexts, a reluctance to analyse statistically in the admin court.
Thank you, Mike, and I completely agree. A question of mine now for Alice. Alice, you took us to paragraph 63 of the judgment in A, and I'd say paragraph 68 probably is also helpful on this point, showing that if it can be seen at the outset that a policy is framed in such a way that a material and identifiable number of cases will be dealt with unlawfully, the policy is unlawful. And if you look at paragraph 70 of BF Eritrea, the Supreme Court is also folding Lord Manser's judgment from the Northern Ireland Human Rights Commission into the Gillick test. And Lord Manser's test there is, the relevant question is whether the legislation is capable of being operated in a manner compatible with the relevant human right, or putting the same point another way around, whether it's bound in a legally significant number of cases to lead to unjustified infringement of the right. And the question I wanted to ask you, Alice, is how is that different from the test that the Court of Appeal had set itself in BF Eritrea, or you highlighted that very helpfully in your slides, of a real risk of, I think it's more than a minimum number of unlawful outcomes. How do those tests differ? Aren't they both essentially about factual predictions?
Yes, I think certainly there's a great deal of ambiguity and uncertainty about what these passages mean. So I think when you read the judgments, it often feels like the court has said one thing, and then you get to the paragraph particularly 63 that you've outlined, and it feels suddenly like they're saying the opposite. And so what we had previously was sort of this bold statement about unacceptable risk of unlawful outcomes, a certain number of those. What we have now is slightly more emphasis, as far as I can tell, on making sure that the analysis is taking place, as I say, sort of at the point of time that you're looking at the policy as it's promulgated. But you're still, as I say, I think there's a fairly porous barrier between saying, well, on a normative reading of, which is what the court is concerned with, of this policy, a reasonable reading of this policy, is there a problem? Is it unlawful? And then they try to distinguish that from saying future factual prediction. But I think necessarily when you're reading a policy and asking, is this going to lead to unlawfulness in a sort of a more than minimal and unacceptable number of cases, you are necessarily, as you suggest, Laura, making a degree of factual prediction. And it seems to me that there's a very blurry boundary between where the court's going to say that does fall within the remit of what a court's comfortable doing in interpreting a policy on its face, taking into account the kind of broader circumstances that we are aware of and can take judicial notice of, and where they're going to say you've overstepped a boundary and you're starting to use too much factual prediction and too much statistical analysis. And I think that's going to be a really important tactical question for framing cases going forward as a claimant, that you're going to be trying to put it within the framing of the Gillick test, but drawing out the fact that paragraph 63 quite clearly means that you're allowed to sort of look at whether there's going to be a more than minimal number of cases, but not spooking the court too much, I think, by heaving too many statistics at them. But I do think that the distinction between the old test and the new test is certainly difficult to grasp. And that's why I think that there's promise here, because I think you can, and I think the court sort of seems to say that the final paragraph I drew out of RA, that the Gillick test should cover pretty much the same ground as what was covered by Refugee Legal Centre. And so I think we can use that very much to resist the suggestion that previous policy challenges that might have been brought can no longer be brought. So I think that's the ambiguity is, it's frustrating in reading the judgment, but useful, I would say, for claimant lawyers. I can't see that it's easy to articulate the difference between the two tests. I don't know if you have a view on that, Laura.
Well, I think that probably until the law is clarified, and I think unfortunately there will be quite a lot of litigation about this, I think that claimants bringing policy challenges would be wise to carefully root their challenges in the wording of the policy, what can be seen on the face of the policy, but also in the alternative. If they would have put in statistics in a pre-A and pre-BF Eritrea world, still put those in on the basis of, to the extent that statistics are required, here they are, they reinforce our point about the reading of the policy. But I absolutely agree with you, Alice, in your analysis. Question for you now, Mike, on unincorporated treaty obligations. Surely this doesn't bite in cases where Section 55 of the Borders, Citizenship and Immigration Act 2009 applies, which of course is a form of incorporation of some UNCRC rights.
That's right, Laura, and I think the analysis there would be that a policy or decision that failed to comply with Section 55, where it does apply, was not in accordance with the law. And therefore, I mean, it's challengeable anyway on public law, normal public law grounds, but conventional public law grounds, but also it's unjustified because of that failure to comply with the statutory duty. But again, as I said in my talk, we're not throwing, even in the non-Section 55 cases, we're not throwing the UN Convention on the Rights of the Child out the window. There still has to be a focused consideration on the rights of the child, because that's relevant to the determination of whether there's been compliance with Article 14.
Thank you very much, Mike. We've just had a very interesting comment from Gabriel Tan saying, regarding Laura's question, and I think this is my question for Alice, I think a distinction to be drawn is between, on the one hand, cases where there's a risk or statistical evidence that some cases might be dealt with unlawfully, and on the other hand, so category 2, cases where you can see in advance that a category of cases will systemically be unlawfully dealt with. Category 1 is seen as not within the court's remit, whereas 2 is. Seen in this way, I do think there's still a fair bit of scope to plead claims under 2. Alice, do you want to address that first, and then I'm happy to come back?
Yeah, I think that's a valuable, and certainly it's sort of the language and the distinction used in the judgment. I think what's blurry for me and what's really tricky and interesting is what the difference is between cases where there's a risk that there might be a certain number of outcomes that are unlawful versus cases you can see in advance that will be systematically unlawfully dealt with. So there's that language of, well, it's inherently systematically unlawful, and we can see that on the face of the document, versus we can predict that there's going to be a certain number of cases that are dealt with unlawfully. I think in certain cases, those are probably going to overlap quite considerably in terms of concepts and meaning. And I think that's where there's a lack of clarity to me in terms of how, and I keep saying I think the boundary between those two things are quite porous, because I do think that when we read documents and we read policies, we take into account the factual background we're aware of in drawing, and they say it's meant to be a reasonable reading of the policy, in coming up with what we think that policy means and what its likely consequences will be on the face of it. So I do think that those categories are not necessarily as distinct as they might appear at face. And I think that's where we've got wiggle room.
I agree. And also coming back, I mean, it's a very interesting question from Gabriel. I think Gabriel's analysis is supported by paragraph 63 of A, but not paragraph 68. So 63 of A does suggest that you need to have an identifiable group where you can say, look, this category, for example, vulnerable prisoners, is going to suffer particularly under this policy. But actually, paragraph 68 simply talks about a significant number of cases which would be decided unfairly and hence unlawfully. And that gets through. And then if you look at paragraph 70 of BF Eritrea, which is also merging in Lord Manse's test from the Northern Ireland Human Rights Commission, you don't again have to have an identifiable category. So I think we would be wrongly limiting ourselves if we understood these judgments as precluding us from bringing a systemic challenge unless you could show here is this identifiable category that will be unlawfully treated under the policy. I think it's sufficient that you have a legally significant number. I should say, we promised that we were bringing these proceedings to a close at 1 o'clock, and it is in fact 1 o'clock. Can I say big thanks to our wonderful two panelists, and a big thanks also to all the people who've joined us on this webinar. Thank you.
Thank you, everyone.